Public Works Department says it's completed most of the disciplinary hearings against employees implicated in the Beitbridge Border Fence scandal. This comes with news that the special tribunal ordered contractors involved in that 40 million project to pay their profits earned from the costly development back to the department. The fence was put up as part of the COVID-19 emergency procurement back in 2020. However, the special investigating unit found the transaction was irregular. Now, for more on this, we're joined by the Department of Public Works Acting DG Imtiaz Faizel in the studio. We're also going to be joined a bit later on by Advocate Selby Makgotho, who's from the SIU Tribunal. Perhaps to start with you, DDG, good afternoon. Thank you very much for your time. It's great to have you with us. Can you just firstly give us your reaction to the tribunal's order that the contractors of the Beitbridge Fence be stripped of their profits?
Yes, thank you very much for the opportunity to speak to this issue. Look, we are very pleased as a department to hear of the ruling of the tribunal. What it means is that our long struggle for almost 2 years, we've managed to declare the profits earned by the companies appointed to the Beitbridge project unlawful. So what it means is that the court has declared the matter neutral, in that we are only required to pay the costs of the company. They've given the company 30 days during which they are required to provide audited financial statements annotating the cost of the project, and we are required to validate that within 30 days, the SIU and ourselves. So quite clearly, this is a victory for us, victory for the taxpayer, and it means that we are expecting some refunds from the contractors involved.
And then now, how far are you as a department, though, in your internal disciplinary process insofar as the irregular awarding of that contract? Because, I mean, there were a lot of officials that were named.
Look, there are a number of officials who are subjected to disciplinary processes. You have 13 in all. Some of these processes I can't talk about. They involve the former or the suspended Director General. They also involve an advisor to the Minister. And these processes are being dealt with outside the department. What we are dealing with internally relate to 11 officials, 8 of whom were involved in the irregular award of the contracts. And their disciplinary processes are now reaching a conclusion. We hope to see an end result by April of this year. And then we have 3 officials whose processes have been put on hold. They've applied to the Labour Court to stay the disciplinary proceedings. So we are undertaking that particular process. So there's a delay there. But with respect to the procurement officials, we hope to see a conclusion by the end of April.
All right. Perhaps to bring you in, Advocate, thank you very much for joining us. Let's talk about your role. I mean, when we look at what the SIU did there, they really spoke of a mess, from prepayments to having a process where here you are having contractors being appointed before the consultants. Talk to us about the case, what you actually were seized with.
No, thank you very much, Mfuno, and good afternoon. What actually the finding of the special tribunal in the whole set of circumstances was that, correctly so, this is an invalid contract that has been found by the special tribunal. But the order actually split into 4 parts. The first part actually details the background and to the reasons behind the ultimate finding. Before the trial commenced, we got an application for the postponement, and that was precisely by the SIU and the Department of Public Works, which are co-applicants in this particular case. And there were reasons for the application, and the judge, when handing down judgment yesterday, she took about 3 pages detailing the reasons behind the postponement of the application. And it was quite critical to have that evidence before the special tribunal, because it talked about the expert reports that could have been of assistance to the special tribunal that we did not have. And again, the question of the witnesses, because in a contract like this, there were quite a number of officials and witnesses who were mentioned in the prior papers, as well as the pleadings. And we did not have the benefit of the insight as to what actually the witnesses were going to say. That is part of the order. And the judge went to town in relation to explaining the importance of having witnesses. I am aware of the narrative that normally would go to say the department, for instance, would say, you know, we are the first to pick up this information, and then we were the first to invite the SIU to come and do the investigation.
Yes.
We are not, it's not something that we hear for the first time. We are familiar with that narrative. But for us as a special tribunal, a narrative like that one could have been of assistance if it goes to court, and that is where it is going to be objectively tested, so that when an order is so made, we'll have the benefit of having had all the information as to what the initial investigations, as the Public Works in this case said they have done, would have come to. So that would have been of assistance. But again, the judgment actually goes further and looks at the factual background in relation to the prepayments, because there were two sides of the point here. Firstly, the main application, which was to review and set aside the contract, looked into the prepayments of 21.8 million as well as 1.8 million that had gone into.
Which was quite a concern, because we've been looking as to who would have authorized these prepayments, what would have been the reasons advanced.
Absolutely, and that is also what we would have loved to hear had we had the benefit of the technical reports and the witnesses, because they would have backed up what was only confined to in the form of affidavits. But now, coming back to the issue, in terms of what actually, yes, it is a finding of the special tribunal that payments were made 4 days after the conclusion of the contract, and the service providers were submitted that they had a reasonable period of time. I think they had up until the 20th of April to complete the job. And that was a 40-kilometer border fence that had to be done within, I think, about 3 weeks. So that was also a finding. But now, money had been paid. So the finding basically talks about the profits now, because that was only what could be backed up by the evidence and what could be established for a special tribunal to make a finding. In terms of the money that has been paid, you would see in the judgment that the special tribunal's posture is that the biggest loser is the state and the public. Yeah. And that is where the matters are. So in terms of the other part of the order was to talk about the remedy as well as the final order.
I like the fact that you do mention that the public and the state is the biggest loser, because the real intention, the sole intention, was to have a border track. And we do not have that. We do not have something solid there, and that's how we find ourselves being at a loss, that even if you're going to recoup the profits, the sole intention was to have a solid border track. We do not have it. I just want to rope in back Public Works. I'm sure you heard there what the advocate is saying, that in most instances you'd find departments wanting to actually boast and say that they are in fact the ones who would have flagged the irregular awarding of tenders, etc., but it's not always the case. What is your take to that?
Look, I think it's quite clear under these circumstances. We, in fact, conducted the investigation and invited the SIU to join us in concluding the investigation. I think that's a common cause. And in fact, we referred a report during July of 2020 to the SIU to commence the process of civil recovery and to assist us in bringing criminal charges against certain individuals. So I appreciate that narrative, but in this particular instance, that is quite the case. And I also want to touch on the issue of the advance payment. And it's quite regrettable. Within 2 or 3 days of the commencement of the contract, you had the advance payment made under false pretenses. Claims were made by the professionals involved, independent professionals, to the effect that materials were delivered on site and work was done that warranted a progress payment. And in fact, 60% of the contract amount was paid upfront almost. And these were referred to the police to investigate the case of fraud. And that's still under investigation. And in fact, we are now entitled to receive much of these funds back from the companies involved. And those who approve these payments, advance payments, are going to be charged, criminally charged. And this is also part of the disciplinary processes being undertaken internally. So it's quite regrettable that we've had this state of affairs. But I believe in this particular instance, on the 25th of April already, when the red flags began to appear, the department commenced with the investigation. And we found the procurement process was irregular. And in fact, the entire implementation project was flawed. And we began to place a moratorium on any further payments quite early in the construction project. So we were able to mitigate any further risk. So I'm quite comfortable that the department, the minister involved, will have taken early steps mitigate risks at the time. And as you know, with quite a few of the COVID-related projects, regrettably, you had companies and individuals who saw an opportunity to gain personal profit. So we were able to nip this in the bud quite early. Yes,
the deviation of processes actually compromise South Africans in this respect. But talk to me now about what you have ordered. You've stated that these two companies need to actually submit or furnish you guys with their financials. I mean, I foresee litigation there, where if we're talking about the profits, they could be disputing, or are they really even going to be that transparent to ensure that South Africans or government gets that profit back?
Well, the order is very, very, very clear, in the sense that within 30 days, actually from yesterday, that was the day when judgment was handed down, the respondents, Caledon River Properties as well as Prof Team, these are the two contractors, ought to provide the special tribunal with a statement of account and debatement that will show the extent to which monies went into and out of their accounts. And furthermore, within 60 days thereafter, the SIU and the department would then have to come together and get the technical expertise report. The technical expertise, which will then talk to what is actually contained in the statement and in the account thereof by the contractors. But I must also indicate that in the process of litigation in this particular matter, the two contractors are the first actually to challenge the jurisdiction of the special tribunal in relation to declaring the constitutional invalidity of a contract. So that is a landmark case that actually it has been remarked as such. It's even part of the judgment that for the first time since we started doing the work of the special tribunal, this is the first to challenge the jurisdiction. And if ever, this is a proper forum, but that has since been disposed of. So the order actually gives more work to the parties to come back, and more importantly, should there be any confusion in regard to the implementation of the order, the judgment says they need to come back so that the special tribunal can then intervene and direct as to where the areas of misunderstanding would have been.
Okay, so in layman's terms, we're going to have them at least keep the money for the overheads, but everything else will be taken back to government. Is that what I'm getting? Yeah,
well, before this particular one, sometime last year, there was an order actually by the special tribunal wherein both contractors had, without accepting any form of liability, indicated that they will abide by whatever order is going to be granted. So that is now standing. So and that is what actually is a concern, even as per the tone of the judgment, because we are not going to be able to get the 21.8 million back. It's only the profits, and that is why it was important for the judge then to look into the foundational reasons behind, so that it's quite clear that at the end of it all, it is only the profits that we are now chasing after. We did not have the benefit of the witnesses who would have told us. But I think it also goes further to say that in the provisions of the Public Finance Management Act needs to be looked into, because now the approvals, we appreciate the explanation that is now going to be acted upon. There's going to be follow-ups. But in terms of the approvals, the judge was very, very clear that unfortunately that is not within the scope of the special tribunal case. But the judge expressed the view that it is a serious matter, a serious concern that needs to be pursued.
They really need to look into those checks and balances there to ensure that they don't have another situation such as this. Advocate, thank you very much for your time. That was the Department of Public Works Acting DG Imtiaz Faizel, as well as in studio Advocate Selby Makgotho from the SIU Tribunal.